Good afternoon, everyone, and thank you all for joining us for today's presentation. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. Today we have Lorena Evans presenting for us. If you are unfamiliar with the format of this event, first Lorena is going to review a PowerPoint presentation. At the end of the presentation, we will have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or the comments section on Facebook. We'll review all questions put in the chat boxes during the Q&A session at the end. Please remember that this is a public forum and Legal Aid is not representing you at this time. Lorena will go over this in more detail, but please remember to keep your questions as general as possible as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I'm going to pass it over to Lorena to get us started.
Thanks, Marissa. Good afternoon, everyone. Thank you for joining us here today. As Marissa said, my name is Lorena. I am the supervising attorney of Legal Aid of North Carolina's Second Chance Project. And today I'm here with you all to talk with you a little bit more about criminal record expunction specifically. As Marissa said, I am an attorney, but I am not your attorney. And so any questions that you might have, we will ask that you keep them as vague and general as possible, not only to protect you and your own privacy, but we are also unable to answer any questions about your specific circumstances. But at the end, I will talk with you all a little more about how you may reach out to see if you can become a legal aid client. And then if you become a client, that is the point in which we can talk to you more about your specific circumstances and as it relates to criminal record expunctions. So to start off, I'm going to tell you a little bit about legal aid generally. And so Legal Aid of North Carolina is a statewide nonprofit law firm, and we provide the free legal services for civil matters and criminal record expunction and driver's license restoration to low-income individuals. The goal is to ensure equal access to justice and to remove legal barriers to economic opportunity. And so we are primarily a civil law firm. The only kind of criminal adjacent work we do is what the Second Chance Project does, which is criminal record expunctions, and we also do driver's license restoration. And so I'm here today to talk with you all about expunction. However, if you are interested to see if you qualify for services and you currently have a suspended license, we may also be able to help you with that. And so today we'll just hear about expunction, but our team also does work on driver's license restoration matters. And so today we're here for the Listen and Learn about expunctions, but we host a number of Listen and Learns on a variety of other legal issues. And so besides this one today, we have one for healthcare power of attorneys, wills, advance directives. We have one for benefits, which can cover Social Security, disability, SNAP, Medicaid, family law, which is simple divorce and child custody, and then tenants' rights and things of that nature. And so you could sign up for those on our website, and all of those do also stream on the Facebook page as well, just like this one is today. So we'll start generally with what is an expunction. And so the word expunction or expungement, they're interchangeable, they mean the same thing, is essentially just the means to permanently remove an offense or a conviction from a criminal record. And the effect of an expunction is essentially once an expunction is granted, the public criminal record of that offense or the expunged conviction is destroyed. And once somebody receives an expunction and the expunction is granted, they can truthfully say that they were never charged or convicted of that offense, only the one that was expunged. And so essentially it is just the means to remove the public record of an offense or a conviction. And I will say on this slide as well that expunction law is state specific. And so today I'm covering expunction law as it relates to North Carolina. And so that is for North Carolina charges or convictions. Expunction law varies state to state. I'm a licensed attorney in North Carolina. I can only speak to North Carolina law. And so this law only applies to charges and convictions that occurred in North Carolina. And so in North Carolina, there are 3 primary types of expunction. There are many other expunction statutes, but with the expansion of the law back in 2020, a lot of those other statutes kind of became obsolete because the law expanded so widely. And so I'm going to talk about the 3 main types of expunctions, which are the 3 categories that most, if not all, charges and or convictions fall under for most individuals. And so by far the most common type of expunction that almost anybody who has a criminal record is likely eligible for is the expunction of not guilty or dismissed charges. And so as it states, not guilty charges, these are all charges where someone may have been found not guilty, either by a judge or a jury. Those are immediately eligible to be expunged upon that disposition. Doesn't matter what the underlying charge is. What matters is the disposition. And so it doesn't matter what the person was charged with. If they were found not guilty, that is eligible to be expunged. The same goes for dismissed charges. Doesn't matter what the underlying charge was for. If that charge was dismissed by the court or by the DA, those charges are immediately eligible upon the dismissal being entered into the court. Most charges that are dismissed after December 1st, 2021 should be automatically expunged 6 months after that dismissal. This is an automatic expunction law that was enacted, and so moving forward, if somebody were to be charged with an offense today, they go to court a couple months from now, and that charge is dismissed, 6 months from that dismissal date, the system should automatically expunge that charge. Now, that doesn't mean if somebody wanted to have that charge expunged sooner than that, they can still file a petition to request the court to expunge it. But if the person doesn't want to do that, they don't have to take any further action if it was dismissed and it occurred and dismissed after the 1st of December 2021, then the system would automatically expunge it, should automatically expunge it 6 months after that. Now, charges that were dismissed prior to that date are still eligible to be expunged. The individual would just need to file a petition, which is just a standard form from the court system to request that the court expunge that charge. And so those won't be automatically expunged, but they are still eligible. I'll just go back and add that there is no limit to the amount of not guilty or dismissal expunction petitions someone can file. So if somebody has a plethora of dismissed charges that span counties, let's say Wake, Johnston, Durham counties, that person can file 3 separate petitions in all of those counties to expunge all of the dismissed charges that they have. So the next type, or the next 2 types, cover convictions, which is where someone was found guilty or pled guilty to a particular offense. We categorize convictions into 2 separate kind of buckets. We have what we refer to as youthful convictions, and then you have adult convictions. So youthful convictions are convictions that occurred before December 1st, 2019, when that person was 16 or 17 years old at the time. And these are most misdemeanors and some class HRI felonies. Essentially, this expunction statute is referred to as raise the age, because before December 1st, 2019, many 16 and 17-year-old children were often prosecuted and their cases were adjudicated in what I'll call adult court. And so a lot of those records are public. Unlike now, if somebody was 16 or 17 years old committing the same offense, or have alleged to have committed the same offense, they would be adjudicated in juvenile court where those records are sealed. And so when North Carolina raised the age of, I'll say maturity, I guess, to 18 on December 1st, 2019, they created this expunction statute to allow some relief for those individuals who, if they were 16 or 17 years old today and alleged to have committed the same offense, they would have been adjudicated in juvenile court where the records wouldn't be public. And so as a way to provide those individuals whose records are public the expunction statute allows for the expunction of those specific types of convictions, most misdemeanors, some Class HRI felonies, committed before December 1st, 2019, when they raised the age, when that person was 16 or 17 years old. And so there's no kind of time limit or weight limit after that. If everyone meets the requirements of that statute, they can petition the court to expunge those youthful convictions. And then what most people are understandably concerned about, and where the fewest amount of people are eligible for expunction just based on the laws and the restrictions that the law places upon individuals, are adult convictions. And so these are convictions that occurred for charges that occurred when someone was 18 years or older. And so some misdemeanors and few felony convictions are eligible to be expunged under the law. Now, what could prevent somebody from expunging their adult convictions? And so the statute that speaks to the expunction of adult convictions is North Carolina General Statute 15A-145.5. And the very first thing in that statute is a list of offenses that the General Assembly has deemed ineligible for expunction. What does that mean? Well, if somebody has a conviction for any of these offenses, the offenses that are listed in that statute, they are not eligible to expunge any of their adult convictions. And so these are convictions that occurred when someone was 18 years or older. However, they may still be able to expunge youthful convictions if they have any that are eligible, and they are still eligible to expunge any dismissed or not guilty charges that they have. So again, what does this mean? If somebody has a conviction for any of these types of offenses, they are not able to expunge any of their adult convictions. So it really only takes one of these types of convictions to disqualify somebody from any type of expunction relief for their adult convictions. And so here on the screen, we have listed some of the more common offenses on that list. There are a couple more that we don't see a lot of. I've done expunction work for about 3 years now, and there are some offenses that I've never seen on a record before, but this is not an exhaustive list, but these are the most common ineligible convictions that we see when we review records. And so the first one is any Class A through G felony. And so, for example, that can be common law robbery, which is a G, sale of drugs, which is a G, Class A1 misdemeanors. We have misdemeanor child abuse, but there's also assault on a female is an A1 misdemeanor, and domestic violence protective order violations are also Class A1 misdemeanors. Any convictions that require sex offender registration, those are disqualifying. Assault offenses, which assault on a female, simple assault, assault with a deadly weapon. The easiest kind of signal to those types of offenses is if assault is in the name of the offense. Those are disqualifying. Any offense that involves heroin or methamphetamines, and then possession with intent to sell or deliver cocaine. Mere possession, felony possession of cocaine is not disqualifying, unlike felony possession of heroin or methamphetamines, which is. With cocaine, there has to be some kind of extra step, I'll say, in terms of having that possession with the intent to sell or deliver. And so again, this is not an exhaustive list. This is just by far the most common disqualifying convictions that we see. And so again, what that means is if somebody has a conviction for any of these types of offenses, it means they're not eligible to expunge any of their adult convictions. It only takes one. So if somebody had one Class G felony and all of their other convictions weren't on the ineligible list, unfortunately, that Class G felony is going to make all of those convictions not eligible. And so this is, walking through kind of how we review a record. This is often the first thing we're looking for because it's the easiest way to kind of determine what somebody, the extent to the eligibility that they have. And so if somebody has one of these, then at most it's any youthful convictions if they have any, and then their dismissals or not guilty charges. So that was a very brief kind of overview of the law. There are a lot more nuances, especially when it comes to expunging convictions. But that is kind of the overarching gist of expunction law. And so now I want to talk to you all a little bit about the process, which is the process that we follow on our team, but is also, I think, just a good general overview of how the process tends to work, whether you hire your own attorney or you are a legal aid client, or if you are able to file your petitions on your own, pro se. This is the general process that I think everyone goes through if they're seeking an expunction. So the first thing is to obtain an accurate and complete copy of a criminal record. This is not as easy as one might hope it would be. We search here on our team at least 3 different North Carolina databases to hopefully pull a complete record for an individual. We also ask clients when we open a file if they have any out-of-state or federal charges and convictions. That is because even though North Carolina expunction law is North Carolina specific in terms of only applies to North Carolina charges and convictions, out-of-state convictions and federal convictions can still have an impact on somebody's North Carolina expunction eligibility. And so even though we are only pulling and really reviewing North Carolina records, we do sometimes have to look at records from other places because depending on what somebody else might have somewhere else, it could affect their eligibility here. And so all of that to say, you're getting a complete record. We search the North Carolina Department of Adult Corrections, Cypress, which is a system that is slowly phasing out across North Carolina, Portal, which is the new e-filing Odyssey system, and then the North Carolina SBI as well, if needed, which should show any charges and convictions that somebody was fingerprinted for. And then in very few circumstances, we might need an FBI record. But ultimately, you're getting a complete record because, of course, having a complete record is the only way that you're going to get to step number 2, which is determining the accurate eligibility. So we're compiling the whole record for a person. Then we are essentially plugging that record into the law. And so, like I said, we often are starting to see if there are any disqualifying. If there is, then we know we're just looking for any youthful convictions or dismissals or not guilties. If there aren't any disqualifying, then we're looking one step further to see how many convictions, how many misdemeanors versus felonies, and looking at all the different moving factors when it comes to seeing about adult conviction eligibility. Once we've done that, we're identifying the correct petition form. The petitions are standardized forms from the NC Court's website. And so all of the forms that are needed to file expunction in terms of the actual petitions are on the nccourts.gov website. And so each type of expunction has its own specific petition form. They all follow the same kind of format in terms of the information that it's asking for, but each type of expunction has its own form. And so if somebody's filing their dismissals and not guilties, there are 2 separate forms for that. For the convictions, there are at least 3 different forms. One for the youthful, one for adult misdemeanors, one for adult felonies. And so depending on somebody's record, the amount of forms can get quite numerous. But ultimately, you're going to find the right form depending on the type of relief that the person is seeking. After that, we're completing it, and if there are any other required documents that are needed, we're getting those as well. And what I mean by that is for the expunction of adult convictions, the law requires that the petitioner, which is the person who is seeking the expunction, file an affidavit that essentially is them attesting that they have met all of the statutory requirements. And then they also need 2 character witnesses to also issue affidavits to essentially attest that they know of that person and of their good character. And so for some expunctions, there are additional documents that are needed to be filed. For most dismissals and not guilties, it's just the petition form that's needed. Some expunction petitions have filing fees. And so there is a form that someone can file to request the remittance of those fees so that they don't have to pay them. But ultimately, you're filing the petition and making sure that any other forms that are needed are completed and also submitted. So this is the point where everything is ready to go. What we're now doing is getting it filed with the court. And so next step is to identify and follow county-specific procedures. It's a lot of words just to say you're filing the form in the county where it needs to go. And what that means is you have to file expunction petitions in the county and the court division where the offense was adjudicated, where it was finalized, whether that was a dismissal, not guilty, conviction. It needs to be filed in the county and the court division. So what does that mean? Jane Doe has charges in Wake County District Court, Wake County Superior, and Johnston District, let's say. So let's say Jane Doe has dismissals in all of those counties and court divisions. They're filing at least 3 different dismissal petitions. You have one for Wake County District Court, one for Wake County Superior Court, and then another one for Johnston County District Court. And so even if somebody only has dismissed charges, you can see how it can quickly add up depending on how many counties somebody has charges in and the extent to the expunction eligibility that they have. For example, I filed at least maybe 15 petitions for one person because the extent of the relief was so extensive. So it can add up pretty quickly. But ultimately, for pro se individuals, that means just taking the petition to the clerk's office in that county. For attorneys, we electronically file in those counties online, ultimately just filing the petitions where they need to go. Then determining and following county-specific procedures. What does that mean? Really just waiting to hear back from the court. For a lot of expunction petitions, especially dismissals and not guilties, judges will often sign them in chambers, meaning not in an active court session. They will just sign them, grant them, hopefully send it back to the clerk. The clerk will execute it and send it back to either the attorney if an attorney filed or the petitioner, which is the person that filed on their own behalf. Some counties may require hearings. Some judges may require hearings. It really does depend. But ultimately, if there's a hearing, you're appearing in court. If there isn't, you're just going to wait to hear back. The clerk will often mail you a copy of the order, which is just the exact petition that was filed with the judge's signature on the back and the clerk's certification on the back. Once somebody has gotten all of their petitions back, hopefully granted, with the judge's signature on the back and the clerk's signature certifying that they've executed it, we want to verify that it's actually gone through. So what does that mean? It just means checking all of those databases where that charge and or conviction occurred, typing in those file numbers that are on the petition, and hoping that nothing shows up. Because if nothing shows up in the database, it means the clerk executed the petition, they deleted it from the public record. If it still shows up, then in our case, if we're reviewing a file and the charge still shows up, we'll reach out to the clerk and just let them know that it's still showing, and then they'll go in and delete it. We'll say quite a few steps, depending on how many expunction petitions are filed, how extensive the relief is. This process can take some time. I would average, for most individuals, if you only have dismissal eligibility, I would say maybe, 6 to 9 months. If somebody is eligible for a complete record expunction, that means dismissals and convictions. Depending on the number of petitions, that could take months, if not years. I've had files come back as quickly as a couple of weeks, and I have had other ones that I have had since I started doing this work almost 3 years ago. And so it really just does depend. Once a lot of things get filed, it's really a waiting game on the court's end. because we're waiting for the court either to review the petition or for the clerk to certify it or whatever the case may be. And so a lot of times, once the petition's filed, it's kind of out of our hands until we hear back from the court. All of that to say, this can take quite some time. So the last slide just talks a little bit about who can still access expunged records. So ultimately, I try to emphasize at the beginning that expunction is really benefit of removing a charge and or conviction from public record, which can help with housing and employment opportunities moving forward for individuals who receive expunctions. But there are certain entities that can still have access to them. However, the access is only for very limited and specific circumstances. And so the first kind of entity that can still access them are DA's offices, prosecutors. They can use expunged records for sentencing calculations if somebody were to be charged with another offense and ultimately convicted of it. The district attorney can review expunged prior convictions to determine the sentencing calculation for that new conviction. They can also do the same thing for determining someone's habitual offender status if somebody were to be charged and convicted of another offense in the future. Another two groups are arresting agencies and law enforcement. Overarching reason that they can still have access is because the records that they keep aren't public. So myself, you, unless you work in law enforcement, you're not able to access the database that they use to see these records. Arresting agencies can maintain what we call investigative records, and so those can include expunged offenses. And then law enforcement can access expunged records in the circumstance in which somebody is applying to be in law enforcement, they're applying for some kind of certification in law enforcement, they can see those expunged records for employment and certification purposes. So I just like to let individuals, the public, know that information, that really the biggest benefit of an expunction is to remove those offenses and or convictions if expunged from public viewing. So somebody were to receive an expunction, if I was to go look up their name and date of birth in the public databases, I shouldn't be able to see any of those expunged charges or convictions. And so that's ultimately, the main benefit of receiving an expunction. So that is kind of all the main material that I have. More than happy to answer any questions. On the slide right now is our project page on the legal aid website, and then the helpline number as well. And we are opening general intake for 1 week of most months. We are not open for intake this month just because we have decided that June and December are months that we are able to audit our current open files to make sure we know where things stand, that we're on top of everything. And so the next intake week that we will have is July 7th through the 11th. And so if you are interested to see if you qualify for legal aid services and can have a file opened, I would encourage you to call back starting July 7th on the helpline number to see if you can get a file open with us.
I do have a couple questions. Remember, if you have a question, you either need to type it into the Q&A box on Zoom or the comment section on Facebook. You cannot unmute in this forum. So if you have a question that you would like potentially answer, you do need to type that into one of those places. The first question is simple affray considered an assault charge? I don't know if you know that.
That is a great question. We are simple affray, I do not believe actually has an element of assault in the actual elements of the offense, but that is something that we would take a closer look at if you would have become a client and we're able to take a look.
Perfect. After someone, I think this question is asking, after an expunction has been filed and it's been approved, how long does it take for that actual deletion to take place from the public record?
Now that depends. Like if as soon as the clerk gets it, it depends when they're able to execute it, which is just mean that the clerk goes into their system and deletes it from their database. And they shouldn't send the order out until they've done that because they have to sign the expunction petition, essentially attesting that they have done that part. And so that's going to happen probably first. What we can find and what is a risk is what we refer to as zombie records, which are, these many of these third-party background check companies don't update the data as often as they should. And so a zombie record is when, let's say someone applies for a job or a apartment or a house or something, and the employer or the landlord uses one of those third-party background check companies to pull a record, and one of those expunged offenses or convictions shows up on that background check, even though the person has the order that says that it was expunged. That tends to be where a lot of the issues happen that we see. And the individual, the petitioner, does have rights to request that third-party background check company remove that. But in terms of the court deleting those expunged offenses, that should happen fairly quickly once the judge has signed it. And the petitioner or the attorney shouldn't be receiving the order until the clerk has done that. So all of that to say, it can depend.
Oh, perfect. To the person with your hand raised, once again, you cannot unmute in this forum. If you have a question, you need to type it into the Q&A box on Zoom or the comment section on Facebook. Um, can you put multiple charges on one expunction petition?
Yes, and you should if all of those charges are eligible for the same type of relief and they all happened in the same county in the same court. So if somebody has a number of dismissed charges in Wake County District Court, all of those dismissed Wake County District Court charges should go on the same form. So yes, that is as it should be, because then you can imagine how plugged up the court can get when you have like so many different of the same petitions for the same person when they all could fit on the same. And if you look at the forms, there's clearly space for more than one. So the answer to that is yes.
Okay. Don't know if you know this. Do you know what the waiting period is for a felony drug conviction?
Now, I can't answer that directly, but if
Gotcha.
a conviction is eligible, there are different wait periods depending on the type of conviction and how many there are. And so there's at least 5 different waiting periods that could apply depending on the type of relief. But for one eligible felony, if it's not breaking and entering, it's 10 years from sentence completion date.
Perfect. In your career, have you ever seen any exceptions to that kind of ban on assault? Or I don't know if ban's the right word I want to use. Like if someone was experiencing maybe like a mental health crisis or something like that, do you know if that plays into being able to expunge something that has where the crime has an element of assault?
Mm-hmm. Unfortunately, the law is very black and white in terms of what can and cannot be expunged, and there's not room for there to be kind of nuanced analysis in terms of somebody's particular circumstances. So unfortunately, the law is going to look at somebody was charged with an assault, they were convicted, that equals not eligible to expunge their convictions. So unfortunately, the law does not allow for kind of those more specific questions about circumstances surrounding the conviction. If somebody has a disqualifying conviction, unfortunately, that's kind of just the end of it. And in terms of expunction law, there's not anything else that can be done to make that eligible or to make that not a bar to conviction expunction.
Is there a benefit such as time, like the waiting, well, not the waiting here, but the time it takes for something to get reviewed and for the expunction to be approved or denied, and having an attorney file the petition versus someone filing pro se? What are the kind of benefits, if any, for that?
Sorry, that was a really long question. I apologize. Can you repeat that?
I'm
Someone walked past my
sorry.
door and I could not hear. No, you're
It's
fine.
okay.
I couldn't hear like the middle of it.
Okay, no problem. Okay. Someone's asking, is there any benefit, such as like how long it takes for a petition to be approved or reviewed, in having an attorney file versus someone filing the
Mm-hmm.
petition pro se?
Mm-hmm. That's a great question. I think, as easy as this to say, as an attorney, I think there are just inherent benefits of being able to have an attorney file and advocate for somebody. And so I, always encourage if somebody can either hire an attorney, which I understand that's not cheap and often not an option for a lot of people, or I always encourage if you're interested to see if you qualify for legal aid, just reaching out and seeing, um, because there are, obviously inherently benefits to having an attorney file, reaching out to the clerk, um, can often reach out to the judge if need be to talk about the filing. And I especially say that if somebody thinks they might be eligible to expunge their convictions, because there are a lot more steps involved. It can get quite complicated. And there's a lot more that could potentially go wrong that has more consequences as opposed to somebody who only has dismissal eligibility. There's a lot less steps, and it's a lot easier for somebody who is on their own, who isn't represented, to fill out the form, sign it, and just take it to the clerk's office. And so, inherently, I think being able to have an attorney file for somebody, there are obviously benefits to that. But I understand not everybody can have that opportunity. And so, if somebody's only eligible for dismissals and not guilties, we often will prepare the paperwork for individuals and then send it to them and walk them through how to just file it themselves, because it's a lot easier. And there are a lot less ways that things can go sideways in that regard. So that's a really long answer to that question, but um, ultimately, I think the relief is the relief is the same by the end of it, hopefully.
Perfect. Um, Someone's asking for charges that were dismissed after 2021 and it's already been that 6 months. Do they need to still file a petition, just reviewing that? Or will that be automatic? There's nothing for them to do.
For most of I would, if you have the file number, I would go check in one of those public databases, which you can find those in all of the courthouses in any county. Usually there's like a little computer either in the clerk's office or right nearby. I would go on there and, type in the file number to see if it's removed. Because if it hasn't been, then you would likely need to file a petition, because it's not all dismissed charges. After that day, it is most of them, and most of them is in like, if there's only one case on a file number that was dismissed, that likely is going. But if somebody, let's say, has a charge that was dismissed, but another charge that was a conviction on the same file number, that dismissed charge isn't going to be automatically expunged. So what I would say is just check to see if it has been, and if it doesn't show up, that would indicate to me that it's been automatically expunged and that person doesn't need to do anything else at that point, because it's already been expunged by the court system.
Perfect. Someone's asking, when does the waiting period begin? Is it after court? Is it after sentencing? When does that waiting period actually start?
For most convictions, eligible convictions, it's going to be, it starts when the sentence completion of the most recent conviction. And it gets complicated. So this is very general. And so, it's easy for me to say, I would encourage everybody to, if they're interested, to reach out July 7th to see if we can open a file, because then this is when we can get into the nuances about if you're eligible, what's the wait period, misdemeanors versus felonies. But generally it is after sentence completion. Except for one single eligible misdemeanor, it is 5 years from the conviction date. But every other type of conviction eligibility, it begins once sentencing is complete.
Is there a limit on how many eligible misdemeanor convictions someone can have expunged?
For misdemeanors, there is not a numerical limit. So if somebody has 20 eligible misdemeanor convictions, they can file for all 20 of those misdemeanor convictions to be expunged. The same does not go for felonies. There is a limit on how many eligible felonies someone can petition to expunge, and the limit is up to 3. Now, for expunction purposes, not to get too complicated, but we can count multiple convictions if they were adjudicated, aka they were all disposed of on the same day or the same session of court. Those can count as one. But generally, it's up to 3 felony convictions occurring within the same 24-month period. But for misdemeanors, there's no limit to the amount of eligible misdemeanors that you can expunge.
Perfect. I think this next question is asking a situation where someone, has had something expunged and maybe they, have another situation in the future. Are they only allowed one expunction? Like, say they have another situation in the future and then that becomes eligible for expunction.
Yep.
Can they have a future expunction? I think is what that question is asking.
For if the charge is dismissed or they're found not guilty, there's not a limit. There is a limit to filing expunctions for convictions, adult convictions. Only get one shot at filing the expunction of adult misdemeanors, and if somebody has felony eligibility, you only get one chance to petition the court for felony expunction relief. And so if somebody, let's say, has a misdemeanor today that's eligible, they petition the court to expunge it, it gets granted. If somebody then gets another misdemeanor charge 5 years from now and they're convicted of that, that misdemeanor conviction is not eligible because that person already received an expunction of a previous misdemeanor conviction. But let's say you have a dismissed charge today, 10 years down the line, you get another dismissed charge, that dismissal is eligible to be expunged. So it depends on the type of expunction relief. But for adult convictions, you only get one shot at petitioning for misdemeanors and for felonies if somebody has them.
Okay. To those of you asking specific questions about whether specific types of convictions can be expunged, we cannot answer that in this forum. That is too specific of a question. Does no contest count the same as guilty in expunction, for an expunction?
Assuming if somebody pleads no contest to a particular offense, then without looking at the record, I would say yes. Yeah. It's going to be counted as a conviction for expunction purposes, yeah. Like a PJC, a prayer for judgment continued, the same thing. That would also count as a conviction for expunction purposes.
Perfect. How does one go about figuring out the file number for their case? And kind of ancillary question to that, on the petition form, is the file number the same as the case number? So some questions
Yes.
about file numbers here.
Yeah, the file number is the case number of that case. And so it would be the case number of that charge or conviction. File number equals case number. And if you don't know, I would just say search your name and demographic information in the public database, and it should pull up all of the case numbers that are associated with you, or at least it should. But file number is the case number. So I mean the same thing when I say file number.
Perfect. I don't know if you can answer this. Someone's asking what would be some resources for them to do a background check on themselves, I think. I guess to figure out what kinds of charges and things might be out there on them. Where would they go
So
find that
you
information?
can, yeah. So there are, like I said, there's many ways to do that. You can look on the portal, which if you go to nccourts.gov, you should be able to get to the portal database somewhere on that page, on that website. And you can do that from your home. You don't have to go to the courthouse anymore to do that for those counties that have gone live on Odyssey on eCourts, which isn't all of them, but by the end of October, it should be all 100 counties. You can search your name and the county specifically, or I can do a statewide search, and that should pull up any cases that are associated with you, and you can filter it by criminal versus like civil, and all of that kind of stuff. So you can filter it just to criminal if that's what you're looking for. For the counties that aren't quite live yet, that you'll want to go to the courthouse on the terminal in the clerk's office and search again your name, middle name included, date of birth. You can search statewide or county, and statewide on that would be just the counties that are still on the Cypress database. And then, be sure to enter any alternate names that you might have gone by, or maiden names or anything like that. You can also request a SBI, a State Bureau of Investigation record, and you should be able to Google, and it kind of pulls you up to the page to request that. And that's going to show, at least it should show, any charges that someone was fingerprinted for, and then FBI as well if somebody wants to go that route. And then the Department of Adult Corrections, same thing. You can do that from your home. You just go to their website. They have a criminal offender record search is what they call it. And you just put your name, date of birth, and if you pull up on there, that should show any convictions where you served some kind of sentence. So either supervised probation or you did an active sentence. If you have convictions that fall into one of those two categories, there is likely a Department of Adult Corrections record for you. And so there's a plethora of pages that you can do that. And you might want to do all of them to get the comprehensive record, because not all of them will likely show everything that you have.
I will answer that. Don't know if you can answer this. Actually, never mind. We're gonna skip that one.
Okay.
Someone's asking more about a expunction charge that was dismissed back in 2022 is still showing up and preventing them, it looks like preventing some work opportunities. So how do they approach that when something that was dismissed is still showing up? Just reviewing that real quickly.
If it still shows, it likely means that it didn't fall under one of the reasons for it to be automatically expunged. It can still be petitioned to be expunged. You would just want to complete the petition form and file it in that county. Now, if you already did that and you got the expunction and it's still showing, then I would reach out. If it's the clerk, like if it's on the court system still showing, you can talk to the clerk's office in that county. If it's like a third-party background check that's still showing it, you can request, if somebody got a third-party background check on you, you can request to receive what they got, and you can reach out to that company. But if this is like, it's still showing up, it hasn't been expunged, but you haven't petitioned for it to be expunged, then I would start there.
I'll ask some clarifying questions. Clarifying question.
Yep.
Asking, all dismissed charges are eligible for expunction with no exception. Is that correct?
Yes, all dismissed charges are eligible for expunction. There's no extra requirements. If it was dismissed, that person can seek expunction of that charge.
I think this next question is someone's asking, they live in a different state now, but they have charges and I'm assuming convictions from when they were living in North Carolina. Can they still get a North Carolina expunction even though they don't live in North Carolina anymore?
Yes, I have several individuals that I've worked with before that live somewhere else now but have North Carolina records, and that's not a problem. The only thing I make sure with anybody who lives out of state now is if you're filing an expunction petition, to make sure the address that you put on the petition is accurate, updated, because clerks will often send the orders back to the address on the petition, and they won't reach out to check, be like, hey, want to make sure you live here, which is what we do with our clients before we send them anything, of course. But the clerks will just send it. So you can absolutely seek an expunction in North Carolina for North Carolina charges or convictions, even if you live somewhere else. I would just make sure that your address is up to date so that if they mail it back to you, when they mail it back, it goes to where it needs to
go. Someone is looking. Wait. Let me see how I can ask this. If someone's looking to maybe immigrate to another country, Would an expunction have any impact on that immigration? Don't know if you can answer
I
that at all.
Yeah, I am not qualified to speak to how a possible expunction would affect immigration issues. I would encourage you to speak to an immigration attorney about that if you have questions or concerns.
Perfect. And then I think this last question is asking about law enforcement's ability to review or see expunged records. If you could just review law enforcement's ability to still see expunged records.
Yeah, so for law enforcement, it's kind of in the realm of somebody is applying to, become law enforcement or trying to receive some kind of like certification in law enforcement. They can see expunged records for those purposes. Arresting agencies, so if somebody gets arrested on a charge, the agency that arrested that person can still see those expunged records for their investigative purposes. And that's just because their records aren't public. I do often, mention to individuals that if somebody receives an expunction, and let's say they get pulled over, for example, and the agency is running tags or running your name, they may still be able to see expunged records when they pull up your information, and it may flag that to them. And so I just like to make people aware of that so that they know that that can, impact the way in which, the conversations go from then on. But I like people to just be aware that they may be able to see those records that way as well.
And another question came in. Someone's just confirmed that once something's been expunged, it won't show up. Will it show up on private databases like or search engines like Google? I don't think they're mentioning the three you spoke about where it could still show up. They just make sure it won't show up anywhere else outside of law enforcement. I think you said the DA and the other thing that you said.
Yeah. Now, if let's say, there's record of it in a newspaper or something like that, it may still show up that way if there was like a news article in reference to an incident. Even if it was expunged, the expunction is not going to remove that reference because, it's a court order, so it's the court system that is required to remove reference of that. And so, an individual might be able to reach out to that news agency and see if they might be able to be willing to remove it that way. But that is definitely a legitimate concern and problem that is valid. You see these websites that will post mugshots and things like that. Unless the mugshot is on the sheriff's department of that county, though they should be removing it from their records. But in terms of like all of these other places that might post them, they're not required to remove it just purely based on the expunction, unfortunately.
Perfect. Okay, interesting one. Don't know if you can answer this one. Does the expungement apply to the DNA that was collected? This might be too specific for this type of form.
Yes, I think so. And so if you reach out and you may become a client and that's a concern you have, we might be able to talk more about it then. But I probably can't answer that right now.
Yeah, no problem. No problem. Okay. I am not seeing any other questions at the moment. Remember, we could not respond to your specific questions asking if your specific charges could be expunged. For those of you who did not get those questions answered, that is why. Um, So I just want to thank you all for joining us with a special thank you to Lorena for presenting and for answering all of those questions. If you would like to review anything that was discussed today, we have posted a recording of today's event to our Facebook page. It will be immediately available. You can access this recording with or without a Facebook account at www.facebook.com/legalaidnc. And then about a week later, you should be able to access it at any time also on Legal Aid's YouTube page. If you would like to register for any of our other Listen and Learns, such as child custody, tenant rights, wills and power of attorney that Lorena mentioned, you can do so on our website at legalaidnc.org/clinics. Thank you all so much, and I hope everyone has a great rest of their afternoon.
Thank you.